Hello, this is Rex Crandall. I'm a CPA and attorney in Walnut Creek, California. And today we're going to be talking about durable powers of attorney. These are forms, legal forms, part of a comprehensive estate plan for people to help plan their estates for transfer of their assets after they've passed away. And first of all, I want to answer the question, why even be concerned about a durable power of attorney? Well, what happens is some people, and seems more common these days, end up getting dementia, Alzheimer's, incapacity, and they're not able to function to handle their writing checks, managing property, financial dealings. And what the power of attorney is designed to do is to appoint an agent to help you manage your finances and pay your bills if you become unable to do so. So we're looking at what a California durable power of attorney does. And you end up with the first choice selecting an agent. So you're the principal, and then you are going to appoint one agent to act if you become uh, incapacitated or have dementia. And that agent will then take over. It will take over the finances either as of the date that you sign the documents, or some durable powers of attorney are effective after a doctor issues a letter stating that you now have dementia or incapacitated. So who would you choose to be your agent under the durable power of attorney? Well, the main thing that you want to look for is somebody who is honest, trustworthy with finances, can follow orders and instructions, and will work with you, for you, and help you meet your objective of taking care of your managing your financial assets, either cash, investment accounts, or real property. Oftentimes, spouses will appoint as their agent the other spouse, which makes sense, and it's often done. One thing that I recommend people do is whenever you appoint an agent under a durable power of attorney, you also appoint an alternate and an alternate to that alternate, so that if one of the nominees is unwilling or unable to act in the capacity of your agent under a durable power of attorney, then the other person steps in, because the problem would be if you appointed one agent and then you became incapacitated, you cannot appoint another agent, because someone who has dementia has no ability to make contracts, to make decisions. They have no authority to do anything in regards to their financial assets. And we are just talking about financial assets. If a person got dementia, Alzheimer's, or something like that, and they needed care, personal care, supervisions, supervised nursing home, or other living things, aspects of daily living, then the durable power of attorney for financial management is not the appropriate tool. The situation there for taking care of the person is a conservatorship of the person, and that is done through a court procedure. And when you're preparing a durable power of attorney, you can have it effective whenever you want. If you're using the uniform statutory durable power of attorney under California law, it's effective on signing. You can also make the form only effective with a doctor's letter, and it's up to you. When you're creating your durable power of attorney, in order to have it authenticated, you need to sign it, date it, describe what details you want to have give the rights to the agent. And then you will either need to have your signature notarized, or have two witnesses sign that they witnessed you signing this document. And I always recommend using the notary method to authenticate a durable power of attorney, because if your agent ever has to handle a real estate transaction, the durable power of attorney would need to be recorded in the public records in order to be able to handle any kind of real estate transaction. This is an important decision to create this form in advance, because for people who do not have a durable power of attorney and they become incapacitated with dementia, and they have no form in place, then what is required is your family would need to take you to court to get a conservatorship of the estate. And that would be much more costly to do, rather than filling out a form that avoids that process entirely. Now, when you're giving the rights to someone to handle your financial transactions, it can also be a license to steal from you, because that agent has complete control over your accounts, investments. So that's one of the reasons that's so critical to have an honest person act as the agent. And you can grant the agent any powers that you wish. It normally includes real estate, personal property, stock transactions, banking, check writing, bill paying, perhaps operating a business, handling insurance, claims and litigation, personal and family maintenance, benefits from Social Security or other entitlement programs, retirement transactions, and income tax matters. So it's an important document. It seems simple, but if you ever need the document, your family will likely think that it was a minor miracle that you had the foresight to create a durable power of attorney, and that you avoid the cost and time and requirements of a conservatorship of the estate. If you have any questions, please contact our office and we'll be happy to answer your questions.